when right before Judge Wanger retired from the U.S. District Court, I think he had rendered a judgment in litigation filed by Northern California users of federal project water, Central Valley Project water, arguing that they were entitled to their full entitlement, whatever that meant, prior to any folks southward getting their water. And he turned that down. I don't know if the case has been appealed or not, and how does that tie in with Term 91, or does it?
It has been appealed, and
okay.
The various attorneys argue different ways on it. I look at it more of a contract case, but it's been argued before the Federal Circuit Court, and there probably will be an opinion in the next several months. I think it does conceivably have an impact on Term 91 and stored bypass requirements to the extent it would either validate some of the area of origin people's arguments that they do have some priority to either purchase water or develop projects. So it'll be a case that we're watching, and it might even be a subject matter of a future report that I might submit to you and the board, because I'm following that case and as many others are, to see how it will turn out. So getting to the kind of the heart of the recommendations that are contained in my report is the issue of possible expansion of Term 91. And I'll go through why and how and some of the practical considerations. Why expand Term 91? The general legal principle is that downstream water right holders should not be diverting stored water. And Term 91 is only a subset of that, and the law, I think, is perfectly capable of allowing an expansion of Term 91 should it be necessary. And in fact, a wider application of the curtailments could spread the obligation to meet water quality standards more fairly, and requiring a broader group of people to comply could help achieve standards and increase the likelihood that they will be met. So for the Delta, the expansion of the term could be very important in protecting Delta beneficial uses. And as you know, the Water Board is embarked on a process to revisit the flow standards. We don't know how that's going to come out. The revisions could require a more natural hydrograph type of approach, could revise the standards, and if they are, then the implementation phase of achieving those standards could obviously look at expansion of Term 91 as one method to achieve them. As far as the how Term 91 could be expanded, as I stated before, Term 91 applies only to 120 post-1965 permittees. It could be expanded to more senior appropriators phased in based on priorities. This was looked at in some detail back in the late 1990s.
And this is the board pages from their water quality control plan document, EIR, that you had given to us.
Yes, and that's contained in your agenda materials. And it's somewhat out of date, but it went into a lot of detail about how it could be expanded. It actually grouped together more senior water right holders, and I think there were 8 groups created, and you would just kind of go from group to group, from junior to senior as needed to make sure that the standards were complied with.
Did I as I understand it correctly, the rights that were involved, the largest holder of rights is the U.S. Bureau of Reclamation. At least that's my reading of this. And then they enter into agreements with other parties on water. Do I have that right?
Well, what happened back in the 90s when the issue of what could be used through the water rights process to implement the flow standards is that the board examined the expansion of this stored water bypass requirement, and the projects and other entities actually came to the board and said, hey, let us try to work out agreements with us and others to try to allocate this responsibility. And in fact, that was done, and there were several agreements entered into, and both agencies, the department and the Bureau of Reclamation, came back to the board and say, hey, don't expand Term 91. We have these agreements worked out. We will be the backstop. We will guarantee that they are met, and we have these agreements with other entities. And that could occur again this time around, But the alternative to that would be actually using an expansion of Term 91 and not having actually agreements between the projects and entities, but actually curtailment requirements imposed upon more senior water right holders regarding stored water. Again, I want to emphasize this has nothing to do with natural flow, abandoned flows. The water rights priority system fully applies in that situation. And you could even go farther and apply a Term 91 type limit to people that are not regulated directly by the Water Board, go all the way down to what are called the pre-1914 appropriators and even riparians.
They'd be really happy about that, right?
Oh, they would be thrilled. And I can't imagine it happening except in a very, very dry year. And in the Delta, again, it gets back to this natural flow versus stored flow. I think that the Delta people probably could have a pretty good argument that at any given time, even in dry periods in the summer, that much of the water in the Delta is natural because of the tidal influences based on how much water is flowing in from upstream. So I think that in Delta diverters, I can't imagine a situation where they would be brought into this. I guess it would be theoretically possible. Again, some of the practical considerations if Term 91 is expanded, like I say, you'd have to have some type of proceeding to impose the term on other permittees and licensees of the board. It could be an existing proceeding, new proceeding, conceivably even by regulation. And again, as I mentioned, in the 90s, the issue of how to phase in the requirements was studied, and you had this groupings of 8 people. That's somewhat out of date, but not hopelessly out of date and could be used. And again, pre-1914 and riparians, that would be kind of the last resort. You'd probably do it more by a letter saying that we've gotten to a situation where you need to curtail because stored water is there and otherwise could be considered an unlawful diversion of water. But again, the natural flow issue, at any given time, there's some natural flow in the system, particularly in the Delta, and to the extent that people are diverting natural flow, Term 91 would not apply. So just to wrap things up, I think we're trying to ramp up and do a better job of enforcing and applying the existing Term 91 requirements. And the recommendation of this report is to consider expansion of Term 91 requirements more broadly to apply to stored water bypass obligation, or as an alternative to that, go through the process where agreements are achieved between the project operators and other entities to more fully and fairly allocate this responsibility. So with that, I'll close unless you have any questions.
Okay, questions from council members? Okay, don't move. Mr. Mills wants to come up and talk about this too.